And actually, I'm changing internets here for a second. I'll just take a second here to. Okay, so if nobody's got anything else, I'll start talking about those. And if you've got things on the same theme, just raise your hand and we can kind of talk through that then. So I got some questions, at least initially here, about sort of the exam generally and how to think about taking it. And I'm not sure I can give you perfect answers here, but I'll try to do my best to kind of give you something here. So for example, I had a question about how to think about structuring your answers, whether to think about IRAC or a term I actually hadn't heard before, CREAC, though I understand what that is. I wouldn't spend too much time worrying about this, right? If you're comfortable using a particular method, use that method. What should focus you is, and this is an important point for all of you, right? What should focus you is the particular question and how it frames your role, right? So if you are an advisor to a particular government, you should be thinking in terms of giving advice to that government. So you shouldn't be looking at this as an open-ended question. You should be looking at it, okay, this is what I'm being asked. This is how I would go about explaining why my advice is this on this particular thing. Here are the questions that need to be answered, where the frayed edges are, and here is my best advice given that, right? So that's the way you should think about kind of structuring it. The other thing to think about here is that you do have word counts, right? So those are going to create their own kind of separate limit on structure here. So I would say worry more about making sure you can provide the answer to the question that you can in the words that you have than using any particular method that you've learned, whether it's IRAC or CREAC. In terms of in the past, people have used all sorts of different models to structure their answers, and they're all completely fine. Answers organized differently get equal grades. It's really about kind of making sure that you kind of hit the key issues and provide a quality assessment of that. Any questions about that, just really quickly? I'll also just say sort of alongside of this, right, you should take seriously the role that the question puts you in that you really want to avoid, given the word limit, going way beyond things that aren't really pertinent to what that person is being asked to give advice on, right? It's not that there's any problem with going beyond that. It's just you have a word limit here, and the question is really meant to focus you on certain things. It's meant to help you to not have to go really far afield and kind of bring in everything. But any other questions on that? Okay, there's another one related to this. So, and this is an interesting question because I'm wondering if there's something more behind it, but there was a question that I got about how the points are allocated on the exam. There shouldn't be any mystery here. There is no cap on the number of points. I wouldn't say there's an unlimited number of points, but in basically each one of these exams, as I've been doing for 14 years, right? There are way more points available in the question than anyone has ever gotten, right? So you're not going to run up against that. And to the extent to which I see in the course of looking through these exams, certain things that people are finding that I didn't have in the key, but should be in the key, I will add that to the key, right? It doesn't mean I'm going to add all kinds of random stuff that doesn't belong there, but if there's something that looks like, okay, this is something that deserves some points, I'll retroactively add it in to make sure anybody who hits that gets it, right? So there's no cap on the number of points, and I'm just adding up kind of the number of points for the questions. As you'll see from the key that's online and from the one we can talk about in a second, right? The way to think about this is there are points for hitting certain things. There's also more points for, and I should be clear, there are more points for things that are central. There are lesser points for things that, are kind of just nice add-ons that you might have hit. There are more points for kind of the quality of the response, right? So it's not just about hitting those things. It's also about making sure you actually talk about them in a coherent way that actually deals with the question at hand. So again, I think the thing to think about here in terms of, again, think about the word limit and think about the role, right? Try to hit all the things that you think are pertinent to that question. If you hit things that are outside of that, it's not a problem in terms of your score, but it's not going to help you because I'm not going to be giving credit for all those random things that aren't part of the question. And it's only going to eat into your word limit. So that's the way I would think about that. Any other questions about that? Because I wasn't sure if I understood the question properly. I'll also just say here along this lines, and don't think this should be shocking. I know no one is happy about the fact that this is curved, including myself. You can be sure that that I will be at the upper edge, the very edge of that curve, right? I spend most of my time the day before I put this in trying desperately to find a way to just get to that edge. I've actually had fights about what decimal place that edge is at with the registrar. So you should be sure that I'm trying to give you as high grades as possible as a class. I just had a question from Christina about the word limit. I don't know yet because I haven't written the exam, which is actually good for this review session because otherwise I would get very uncomfortable about answering your questions. Generally speaking, the exam will be as a whole between 3,600 and 4,200 words, split up between different questions. That's kind of what I've found over the years as the sweet spot for allowing you enough room to actually be able to answer the questions coherently, but also not long enough to make you feel like you need to be writing forever, which is very much not the goal. How that will be split up will depend on sort of what questions are actually asked here. Any other questions related to that? And each question will very clearly state the word limit, and as you have seen, the instructions say to list the number of words in your answer at the end. Along similar lines, I had a question about citing specific cases or treaties, right? You should never feel like you absolutely have to cite a specific case or a specific treaty, right? If you state the rule, you stated the rule. I'm not worried about that. There are situations where the case, though, does stand for a particular rule. And so you should be thinking that that's where you do want to do it. So Nicaragua stands for certain rules. The Libya-Chad case doesn't, right? The Libya-Chad case is something we used to kind of help see how these rules work, right? So I think that's the way you should be thinking about it, where the actual case stands in for a rule, or where you want to use the case rather than the rules of the case to help explain your logic. So for example, as we'll get to in a second, if you're talking about the meaning of innocent passage for straits under customary international law, you don't have to say the Corfu Channel case, right? But if you want to help use the logic of the Corfu Channel case, it doesn't hurt to say Corfu Channel case. So you should be thinking about it in those places, right? Where it's actually helping to elucidate your analysis, or where you are using it to stand in for a particular rule because it does stand in for the particular rule. You don't need to be citing cases generally, right? The rule is the thing to be focused on. In terms of treaties, right, the same kind of logic applies, right? There are certain cases where, right, the rule is the treaty provision, right? Article 2.4 is the rule, right? So that's where you might want to say Article 2.4, though again, if you don't say Article 2.4, but you state the rule of it, that's fine. Same thing with Article 51, right? Those are things that are the rule. There are other cases where there are lots of rules that we've seen in a particular treaty, say additional protocol 1, right? It's not key to state the particular provision you're looking to, right? The idea is to kind of know the general rules in it. Does that make sense? Again, you should never worry that you have to put that down. If you put down the rule, it'll be fine. But I mean, that's the way to think about it. It's where is the actual provision or the rule doing the work? When is it just sort of standing in for a general proposition that we know? Does that make sense? And as always, I mean, this will go back to something we'll talk about when we talk about that particular exam, right? The exam I do know what we've talked about this semester. I do remember our conversations, I promise you. The exam will be weighted towards the things we talked about, not towards things that we might have talked about. If we didn't talk about a particular provision or we didn't focus on a particular provision, right, it's unlikely that I'm trying to get you to state that particular provision, right? That's not what's going on here. You should expect that the weight of the things on here will be the weight of what we talked about. Okay. Any other questions about that? Okay, and then one other broader question that was out there is, and at this point, I mean, I'm not sure that I can really help you on this because you all have your own ways of doing these things, and I think you know your own study styles better than I do. But it was a question generally about how to think about outlining for organizing your thinking on this. the way I would think about this, right, is basically everything comes back to the first section of the course first and foremost, right? So one way you can kind of imagine an outline for this course is one way, right? But also helps you to think about how you might think about the answers to questions here, is that, you know, everything comes back initially to questions about who the actors are, what responsibilities or obligations do they have, where do they come from, what rights or powers do they have, where do they come from? That has you then looking at questions about treaties and custom, right? And then from there, right, you're asking questions about, okay, given that, what area of law are we in? Right? And that takes you down one particular spoke. So you can kind of imagine this as kind of a hub and spoke model where kind of you're always coming back to the hub of questions about actors, rights, responsibilities, and then you're kind of going down one particular spoke into a particular area of law and seeing kind of how the analysis would go once we're in that particular area. If it's unclear if we belong in that area, or if it actually involves multiple areas, then you kind of climb back to the hub and you go back down the next kind of spoke to kind of work through what that area would say. Does that make sense? And that would be my best sort of description of kind of the functional structure of this. Now, when I say you always go back to that hub, right? So you should always be asking questions about who are the actors here that matter and what are their obligations, rights, or responsibilities. The question will tell you whether or not you need to get into any depth with that. So if the question says that, you know, it's about the United Kingdom and says the United Kingdom ratified the Geneva Conventions, you don't need to get into whether or not the United Kingdom is a state. The United Kingdom is a state. We know that, right? You don't have to go into kind of doctrines about statehood. If it says that Gobbledygookstan, you know, an unrecognized country has tried to ratify the Geneva Conventions, but never heard back from the Prime Minister of Switzerland, well, then you might be asking, is Gobbledygookstan actually a country, right? So that's going to be where it comes in, right? You're not asking that question. It should be clear on the face of it whether you're meant to be getting into those kinds of first order things. With regard to the UK and the Geneva Convention, again, if it tells you it's a Geneva Convention, then you know they're going down that line. If you know instead they were talking about AP1, or Additional Protocol 1, and it says they didn't ratify, well, then you want to back up and you kind of want to ask, okay, they haven't ratified this. Is this nonetheless binding on them as a matter of custom, right? Does that make sense, right? But you come back to there, make sure that there are no questions there, and then kind of run from there into the other kinds of questions that might come up in that particular area once you know what the responsibilities are or where they come from. Does that make sense? And the same thing would go, by the way, in a reverse order. We'll probably see this in a second with regards to courts, right? Again, you should always be asking when you're talking about a particular possibility of going to a particular court, right? We have to remember that you can't just go to courts, right? There has to be sort of a hook that actually creates jurisdiction in that court, that creates some legal obligation by a certain state or other actor to actually go to that court, right? So the same thing's going to come up. I have a question here. And yes, so this is just a question that came up about sort of ratifications by states. I will always tell you, including with the Geneva Conventions, which I've told you everyone has ratified, but I will always tell you whether or not states have or have not ratified any treaty that is relevant for a particular question, right? So I will give you that information up front. The same thing will be true, right? If I'm ever asking you to look at a treaty provision that is not a treaty provision that you should know well, right? Whether it's a fake treaty, like you've seen in some of the exams, or a real treaty, I will give you the treaty provision, right? I'm not going to give you Article 2.4, right? I assume you know what that is and where that is, right? But if we're talking about something that's more bespoke, right, that you haven't really seen before, that we haven't really talked about, I'm going to give you that language to look at. Any other questions about any of that? And you know, the whole muting thing makes this a little bit weird for me. I don't know how people are doing, but if at any point you want to guffaw or say no, or tell me to stop because I'm making things more confusing, please do, okay? Because otherwise I'm just talking at dead air here. And the real risk here is once I get started talking, I can say random stuff that's not in your outlines and you'll be like, whoa, what was that? And we don't want that. So please stop me if I start going on a weird tangent. Okay, so now going into some of the questions here. And again, as I said, one way to do this is I'll talk about the question I have. If you have something that's around that, let me know and we can kind of go back to that. So I had a little bit of a question dealing with how to think about recognition of governments, right, and the different models that are out there. Right. As a reminder, right, we don't have, so there were two issues when we talk about recognition of governments. One is a question about who can bind a particular state, right? When will a state be bound by a particular government? The other is then a question about whether to recognize and work with a particular government. As I said, with regard to the first, right, we'll remember, right, the black letter rule is clearer, right? That's going to be something like the rule from the Noco arbitration, right? The Estrada Doctrine that basically says effective control is what matters, right? If the government in effective control is the one that binds the state is bound by the government in effective control. But with regard to recognition, we saw there's no clear rule here as a matter of general international law. States choose who to recognize, and this is true also for international organizations, right? International organizations have their own rules with regard to who to recognize as the representative of that state. Just as a reminder here to go to that question, what we basically saw were kind of four approaches. We saw something like the Lie rule, which is basically, the Lie rule that basically was that so long as basically the same thing as the Estrada Doctrine, that you basically should recognize the government in effective control, right? We then saw something like the Tobar Doctrine, right? One that would establish some kind of rule for legitimacy, that would ask whether or not the particular government was legitimate along some form. We noticed, though, there were different ways of assessing that legitimacy. One thing that came up here in the specific question was where the US's argument about China came up here, where they basically said that China, under the UN Charter, might have been able but was not willing to comply with the charter. This fits into this kind of this Tobar type doctrine, where you're basically saying we're going to assess the legitimacy of the government according to some standard. Here, the legitimacy is going to be assessed according to whether or not they're willing to abide by obligations, let's say, with regard to human rights in the UN Charter. If in fact they are, then we'll recognize them. If they're not, we'll recognize a government that is, right? So that's where that fits in. And then you had these two other options, which were the one that India had kind of put forward in these cases, which was basically just kind of let things play out versus a kind of finally just have the members vote kind of rule, which is what ends up basically playing out in the UN, at least. That's always we said, this is something that different institutions might choose to do differently. Any questions about that? Did that get at the basic issue?
Professor, I have a question.
Sure.
So I'm a little confused. I know the Tobar Doctrine, but I'm looking through my notes. What is the Noco Doctrine and how is that related?
So this is the rule from, I want to make sure I don't say anything stupid here. Where is this in the recaps? But this is the basic rule that says that effective control is what matters, right? There are different names for it, right? It comes from the Noco arbitration. It's also sometimes called the Estrada Doctrine, right? There are different ways, but it's basically the rule of effective control.
Oh, thank you.
Anything else on this? Okay, I had a few questions on the law of the sea, right? So let's see what we can kind of get at there. Let's see if I can pull up the recap for this, because it might help in terms if anybody has other questions here, since it kept coming up. All right, so okay, so this is the recap that you have on the law of the sea. there are a few different ways to think about what's going on here, right? So one thing that's going on here as we think about this is it's laying out kind of these basic areas that have developed over time with regard to the law of the sea. And so we're seeing now there is kind of essentially now there's the Territorial Sea, which has certain rules that apply to it, right? Which used to be 3 nautical miles, now is 12. There's the Continental Shelf and EEZ, which are each 200 nautical square miles. And then perhaps there's things beyond that, right? So that's kind of one thing that's being set up there. There's also going to be this question here, which we can come back to in a second, right? Of what the particular rules are for the Territorial Sea with regard to passage, either innocent passage generally through the Territorial Sea, or what ends up becoming the rule in UNCLOS for straits, which is what's it called, which is transit passage, right? That's going to be the differences here. So we can talk about that in a second. One thing to be thinking about kind of is this general kind of regime. A second thing to be thinking about here is we've got this relationship between different rules at different times, right? So we've got custom developing over time, and we have certain evidence of what the custom is at certain moments. We've also got these attempts to draft treaties during this period that might, if states have ratified it, create new rules for those states who've ratified it, or might even have crystallized into custom since then, right? So that's kind of the other thing that's going on here. In terms of the rules here, right, we basically talked about these different areas, right? One we talked about was the question about the Territorial Sea and specifically with regard to straits. We saw there that the general rule for the Territorial Sea, both as a matter of custom and under UNCLOS, seems to be innocent passage. And we saw there that UNCLOS lays out specific rules about what is or isn't allowed within the Territorial Sea, both in terms of what kinds of passage is allowed by innocent passage and kind of what kinds of regulation are allowed by the territorial state. Again, just as a note here, the assumption here is that aside from these rules with regards to innocent or transit passage, the Territorial Sea is part of the state, right? It's the territory of the state, right? So this is an exception to the general rule that states can do whatever they want in their own territory. In the Territorial Sea, we saw the customary rule and apparently the treaty rule is one of innocent passage where they do have this limit on what they can do. They must allow this kind of passage, right? We saw with regard to straits, this rule might be a little bit different. In the Corfu Channel case, we saw that as a matter of custom, innocent passage did seem to apply to straits that are international highways for international traffic by sea. But we saw that under UNCLOS, right, there was a renegotiation here that created kind of the concept specific for straits of transit passage, right? The idea here being that with regard to straits, at least, they were going to leave open the possibility that states could have submarines go submerged through them, which would not be allowed by innocent passage, as well as overflights by planes without permission, right? So that was kind of the big difference there. Again, one thing to note here, I knew this came up during class and it's just worth kind of remembering. When we're talking about straits, right, we're talking about this because we're talking about the Territorial Sea. So if there is an area in the strait that's not part of the Territorial Sea, right? So if the strait is more than 24 nautical miles wide, hopefully that makes sense. If the strait is more than 24 nautical miles wide, the area in the middle is the high seas. States can simply go through it. There's no issue of worrying about whether or not there's transit or innocent passage, right? It's only if you're talking about an area that would otherwise be part of the territory of the state within that strait. Okay. And again, the issue here, just as a reminder, right, we have potentially two different rules here under custom and under the treaty for straits, right? We know what the customary rule was at the moment of the Corfu Channel case. We know that's different from the rule in UNCLOS. If we have to figure out what the customary international law rule is today, that would obviously create complications where we have to figure out sort of exactly what is custom now years after that Corfu Channel case. Does it reflect the decision in that case? Is it different than the decision in that case? Has it actually become the rule of UNCLOS? But those are questions that would be a question you'd want to raise, not something that's necessarily answered. Any questions about the that particular issue about straits and straits, transit passage, innocent passage through the territorial sea? Okay, not seeing anything. The other issue here is with regards to the continental shelf, which we talked about. Right, again, here we're talking about kind of how custom is developing here, and then how treaties are coming into play with regard to that. The key thing here, right, is we see that we now have a pretty well recognized customary rule embodied in these treaties that states do have the rights to 200 nautical square miles of continental shelf from their coast. Right. As a matter of treaty, we also have an exclusive economic zone that's 200 nautical square miles. It's not clear whether that is custom at this point, but there are also going to be these questions about how to demarcate either coasts, how to demarcate continental shelves where states are either facing each other or next to each other. And there we saw kind of the questions about what the customary rule might be, as well as the rule that's now in Mfn Clause, and the way in which the ICJ generally resolves these particular cases. We also then talked a little bit about what happens if you're talking about continental shelf beyond 200 nautical square miles, right? So the issue here is that the actual continental shelf is a geographic feature. It might actually extend beyond 200 square miles. And we saw that here it sets up this system where you can go to the Commission on the Law of the Continental Shelf, and you can give it basically you can basically give it your information about what you think the continental shelf should be for you. If it makes a recommendation, that recommendation is non-binding, but if you apply their recommendation, it applies to everyone else, right? This is that you cut, I choose sort of model in international law. Any questions about any of that given? I mean, I don't know if I answered everyone's questions with regard to it, but let's make sure. Okay, Kaylin?
So basically the only difference between transit passage and innocent passage is the fact that transit passage gives the submarine rule and the overflight rule.
Yeah, it basically creates more possibility. It creates a little bit of a different standard for what can happen with, with regards to kind of things going through it. Yes, that's basically the rule. And you have the provisions in the book there too. That is the key difference. Anything else on this? Okay, so that's what I had on Law of the Sea for now. Then there were a couple of questions about the GATT and the WTO law. So the first was just sort of making sure we understand kind of when the four pillars apply, as well as the three-part test we talked about in the shrimp turtle case. The way to think about this, right? So as I mentioned, right, the GATT is now part of the WTO, right? The WTO is the institution that basically monitors and enforces the GATT, right? The GATT is part of that. So the four pillars of the GATT remain the four pillars of the GATT. The GATT is WTO law now. Today, those four pillars would still be the basic rules of WTO law, along with other rules that have also been brought in. The three-part test we were talking about, right? So Article 20 is part of the GATT as well. So the four pillars are part of the GATT. Article 20, which creates the potential exception to those basic rules, is also part of the GATT. So that was always part of this and continues to be to this day. The three-part test is something basically elucidated by the WTO appellate body. So it kind of it might have been there already in a sort of a nascent form before the WTO. It's certainly part of how the WTO now and how WTO members approach questions about GATT compliance. Right, so the question would be always, is there a GATT obligation here that's been violated? If there has been one that's been violated, right, if MFN has been violated, for example, or if tariff bindings have been violated, then we turn to Article 20. We ask if there is an exception that applies in A through J. If there is, we then still have to turn to the chapeau and make sure there isn't unjustified or unjustified or arbitrary discrimination or in a disguised restriction on trade. Right? So that's the way you would, that's the basic way in which you would do any kind of analysis about a rule under the WTO. Any other questions about that? Ben?
Professor, I have a question about the exception for free trade areas. Does it only apply to most favored nation? I'm thinking through how it would apply to national treatment, and I'm not sure there's a situation where it could arise, but I was still curious.
So we have not talked about this, so you should assume this is not something you're responsible for. There is an open question about exactly what rules of the WTO a state could get out of in creating a free trade area, right? The general rule is if you went to the actual provision of the GATT that creates the possibility for free trade areas, it basically says that nothing in this should prevent the creation of free trade areas. The question then becomes, well, what does that mean? Nothing should prevent, right? Does that mean that you could allow for discrimination in the form of against national treatment in order to create the free trade area? It seems like the WTO would say, no, you can't do that. Right, but it's unclear. There's a little bit of question there exactly what's allowed. Certainly, certainly a violation of MFN is allowed because that's what's creating the free trade area. Everything else is a little bit of open.
Sure, and additionally, this one's a little bit quicker. So does Article 20, the exceptions, does it include safety or just health?
So if you look at the actual specific provision, it talks about human, animal health, and safety, right? So that's what you're talking about there. So it includes some level of, let me make sure I actually get the provision right, but now that you're saying it, this is where I don't want to screw things up.
And the broader question was, how far does safety go, or is that an open question?
That would be automatically an open question, right? So B is necessary to protect, so it's not health and safety. What it says is, and this is why it's key, right? It's necessary to protect human, animal, plant, life, or health. Right, so that's the provision we're looking at, right? And so the question would be, is it something that's necessary to protect human, animal, plant, life, or health, right? If it is, then it's going to come under, but the question about whether something is in fact meant to protect human, animal, or plant, life, or health will be an interpretive question that one would have to do.
Thank you.
Anything else on this? We had a more specific question with regards to kind of the TRIPS waiver and compulsory licenses. It's actually something that's now kind of in the news. Basically, the way to see this is that there is a provision of the TRIPS agreement that actually allows for compulsory licenses, but it creates a specific process for doing that. Right? We've also seen that's now been amended to create kind of a process to allow for licensing across countries, right? We talked about that. That's the compulsory licensing provision, right? It allows it, right? We don't have to do anything else. What a waiver would do, a waiver would basically allow you to not have to follow those rules, right? So if you're thinking now about kind of the situation going on with intellectual property and creating a vaccine, right? States can simply use the compulsory license provision if they can use it, they can use it, right? They don't need to do anything. They don't need a waiver in order to do that. What a waiver would do, and this would be a waiver by the members, right? Again, everything's by consensus. What a waiver would do would in some ways allow a particular state to not have to follow the otherwise existing rules on how to do compulsory licensing, right? And part of the debate, right, that's going on right now, right, is people saying, compulsory licensing rules are great and all on paper, but it's actually really hard for states to figure out what they can or can't do. This is having a chilling effect. We should just have a waiver so states can just go and start producing stuff. But that's the difference, right? The compulsory licensing rules are rules that apply anyway. The waiver would be something that allowed states to not have to apply the otherwise existing rules. Any other questions about that? Okay, there's also a question now moving on to investment. So if anybody's got something on trade, before moving on, I'll hit that. On investment, there was a question just about the difference between the various rules we saw. We saw two of them on expropriation, right? So the question here is, so there are certain rules that apply, and these go back to other things we talked about with regard to prompt, adequate, and effective compensation. There are certain rules that apply once you've decided that something is an expropriation. So the whole issue is whether or not something is an expropriation at all, right? If a particular regulation by a state isn't an expropriation, then we don't have to worry about providing, say, compensation, right? So the question is what counts as an expropriation? And the two rules you had here were one that was mentioned, that I mentioned from the metal-clad case, which basically gives you one extreme, right? And this basically says that any incidental interference that deprives the owner of the use or reasonably to expected economic benefit of the property, anything like that is going to be an expropriation. What that basically means, if you're using the metal-clad definition, is that pretty much any regulation could be an expropriation, because any regulation that changes the value of your investment by making you, say, invest in, say, new equipment or pay your employees more, right, is going to be at least an incidental interference with your reasonably to be expected economic benefit of the property, right? The test we saw in L, G, and E, right, was looser. That basically said that in order for something to count as an expropriation, right, and again, key here, we have to remember that they're actually interpreting different provisions, right? And here we're talking about provision that talks about tantamount to expropriation. Right, they say that it must effectively neutralize the benefit of the property for the foreign owner. And then it basically talks about how it's a measure of the economic impact, right? It's the question is whether or not it actually interferes with reasonable expectations. And you have to look here to see whether the impact is actually substantial, right? If it's not a substantial impact, if it's not really neutralizing the benefit of the property for the owner, then we're not going to call it an expropriation and you won't have to apply those rules. Does that make sense? Other questions about that? This would apply, because we're not going to talk about that exam unless we want to get to it. For example, in the second exam, there's a question about frozen assets. So you'd want to figure out whether freezing assets actually is an expropriation or not, right? That's where it could come up, right? And whether it doesn't fully neutralize the benefit of the investment for the person to freeze it. Probably yes, that seems like the right answer, but that would be kind of the question there. Okay. Then we had a couple of questions about self-defense, right? And so the key here, right, was, this was getting a little bit confused, I think, as we talked about it, so I'll just try to clarify this, right? There is really no question that as a matter of black letter customary international law, right, which would also then apply through Article 51, because Article 51 seems to recognize customary international law, that anticipatory self-defense as understood through the Caroline Doctrine is allowed, right? So if you were talking about, remember the formulation in the Caroline Doctrine, the formulation by Webster is that the necessity for preemptive self-defense must be instant, overwhelming, leaving no choice of means and no moment for deliberation. If we're applying that formulation, right, everyone agrees that that is customary international law. I mean, I'm not saying, when I say everyone, maybe there's some state out there that doesn't, but that's the black letter rule, right? If you're talking about that, there's not going to be a question. There is going to be some pressure on what exactly imminence means there, right? What does it mean for something to be instant, overwhelming, leaving no choice of means and no moment for deliberation? And if you push hard enough on that imminence question, you're going to eventually get to the kinds of arguments that are being made now for something like preventative self-defense, right? Where you're actually going beyond sort of something that's imminent to something that's not really imminent at all, where it's the mere potential of it. As you'll recall, right, the ICJ looks pretty poorly at that kind of argument in Uganda versus DRC, right? But in general, we would say that's not where the law is now, even if some are pushing in that direction. States might have an interest in pushing in that direction, right? You may, as a particular actor in a particular exam question, wants to kind of push in that direction, but it's with the recognition that that's not where the law probably is now, right? You're pushing against kind of where things are, right? Does that make sense? Right, so anticipatory self-defense with a really narrow understanding of imminence, no question. The farther you push, the harder you push on imminence, the farther back you push imminence, the more it's going to become controversial. When you get to preventative self-defense, you're going to be in the area of sort of true controversy, where it's probably not the rule, even if some states are trying to argue for it. Beyond that, there was a question sort of how, who's, just to think about this, how or who is this going to be assessed, right? Someone's argument here for anticipatory self-defense. right? The way to think about this is there are three levels to this, right? So at the most basic level, always, those who are assessing this are other states, right? And so we're trying to understand how other states are going to react to this in the moment, right? Will they see this as a violation or not? Because that may lead to certain kinds of consequences from them. But also over time, in terms of the creation of either new custom or a rethinking of what the treaty means, you're looking to how states have reacted to it in terms of both their practice and their opinio juris. There's a possibility here, though, that you could have a reaction by either the Security Council, because the Security Council can take cognizance of these issues under either Chapter 6 or 7. So it could choose to come in and sort of say whether it thinks this is or is not has been an act of aggression or not that triggers its powers, right? The Security Council could do that, right? It has the power to do that. Of course, there's always going to be the P5 veto, so there'll be questions about whether it ever would, but it could. There's a third level, which would be whether or not any of these questions could go to the ICJ, as you saw in Nicaragua or in Uganda versus DRC. But the thing to remember there is the ICJ will only come into this question if either there is contentious jurisdiction because both states have agreed to the jurisdiction. So it's not going to simply opine on this generally, or if the General Assembly or some other UN body has put before it an advisory opinion, right? So it's only going to come in here if someone actually brings it in a way that it's allowed to do. Otherwise, it's not going to have a role to play. Okay. Does that answer that question? Any other questions around that? I think those are all the questions I had sent in before. Anything else? Any other questions people have on their lists that they want to get out before? Okay, Caleb and Ben.
So for the application of domestic law outside of someone's borders, we went over a series of US Supreme Court cases about that went through the in effects test, and then a European system that went through an implementation test. But is there any black letter international role, or is this more or less application by various different communities?
The latter, right? The way to think about that as a matter of international law, right? So there is a possibility, again, I haven't written an exam here, but there is a possibility here that I could tell you that you were in a particular domestic system that had a particular rule, right? Unless we were talking about maybe the US and sort of Nabisco being the rule. But in general, I would have to tell you what the rule is, right? That would be a possibility. If you're talking about this purely as a matter of international law, well, then you're kind of raising the issue that there is overlapping possibilities for jurisdiction, right? States have multiple possible ways in which they could claim jurisdiction, which will overlap. The only thing that will necessarily dictate kind of how to govern, mediate those claims of jurisdiction will potentially be a reasonability test, right? But beyond that, we don't have anything, right? It's going to be, there will be competing claims for jurisdiction. We also do know that, right, you're on strong ground, the state's on strong ground claiming nationality or territory. It's on pretty strong ground claiming protective or passive, but less strong ground. If it's talking about universal jurisdiction, now you really have to kind of make a strong argument. There's actually a claim here. Anything else on that? And also a reminder, those only apply to prescriptive jurisdiction and adjudicative jurisdiction. Enforcement jurisdiction is only within your territory, right? You cannot enforce in another state's territory. Okay, Ben?
Sure. So regarding reservations to multilateral treaties, could you explain it real quick again? So, I know that's a lot, so I can narrow it down just a little. So regarding the object, if it's not against the object and purpose, or at least the state doesn't think it's against the object and purpose, that reservation just doesn't apply between the state that's objecting, correct? It still applies to everyone else that doesn't object.
So I didn't quite catch you said. So the way to think about this, right, is if you have a reservation to a multilateral treaty, right, the general assumption, right, is that if no one objects to the reservation, right, then you come into, it's easier to think about with regard to states, right? So let's just use states here to kind of make this easier. if the United States is trying to join the ICCPR with a reservation to the provision saying that it has to prohibit war propaganda, right? It says we will agree to this whole treaty minus this provision. If no one objects, they've ratified the treaty, but they don't have to abide by that particular provision. If a state objects, but doesn't say that they're objecting to it coming into force with that reservation, the United States has ratified the treaty minus the thing that they're trying to reserve from. So they're still not bound by that particular thing. If a state says, we actually object, right, to it coming into force with this particular reservation, then there is no treaty between the United States and that particular state. But with regard to every other state, they have ratified the treaty, but simply aren't bound by that particular provision. Now, there's a question here about object and purpose, right? So as I said, the way the ICJ left it and the Vienna Convention on Law of Treaties left it unclear exactly what role object and purpose actually plays here. The modern position of the International Law Commission seems to be that there's a distinction between objecting to the reservation just generally and something being a violation of the object and purpose. If the issue is that the state has tried to have a reservation that violates the object and purpose of the treaty, it's not about whether or not a state objects to it or not, right? Whether or not a state objects to it or not might help you know whether it violates the object and purpose. But if a state actually tries to ratify a treaty with a reservation that violates the object and purpose, the position of the ILC, which follows some of these human rights courts, is that the attempt at reservation is simply invalid, right? It's as if the United States never made that reservation at all, right? So here you would imagine sort of some of these reservations that states have saying, we agree to this treaty minus any provision that we don't like or choose to not like, right? You'd say, okay, that seems to violate the object and purpose of the treaty. It's an invalid reservation. And in that case, the state is bound by the whole treaty, including the thing that it tried to reserve to, because it simply was an invalid attempt at making a reservation. That's controversial, obviously. A lot of states don't like the idea that they'll be bound by something that they specifically said they weren't going to be bound by, but that's kind of where the ILC at the very least is following these human rights courts. Does that make sense?
Yeah, thank you.
And this is, you see here where I'm trying really hard not to make things more complicated than they already were. Priya?
Okay, I don't know if this is important, but I have a few notes on it. Can you go over under the GATT WTO thing what automaticity is?
That's right. Sorry, I missed that. Yeah. So the idea here was that the difference between the GATT model of adjudication and the WTO model of adjudication was that under the GATT, right, it was all ad hoc, right? Because the GATT provided for the possibility of dispute settlement, but it didn't explain how it would happen. So everything about that process had to be agreed upon by the members. So you had this system where, you know, the member would complain of another member, would ask for a panel, that would have to be approved, which meant that if anybody objected, there wouldn't be a panel. They would then have to choose panelists. Everyone would have to approve. If anybody rejected it, there wouldn't be a panel. The same thing would go for the actual decision, adopting the award, and then finally kind of some kind of sanction, right? Everything depended on kind of everybody agreeing to that going forward, which meant that you would have some kind of possibility for it stopping. What the dispute settlement understanding under the WTO did was it created a system whereby everything simply happens along a pre-specified timeline, and you require a consensus to stop it from happening. So now, once you complain of another state, right, there's going to be a panel set up within a certain amount of time, unless there's a consensus to stop it. At a certain point in time, there will be panelists unless everybody stops it. There will be a hearing. There will be an award. There will eventually be sanctions unless everyone chooses to stop it. So the idea here, that's the automaticity here thing, right? Everything is happening according to this preset timeline, and you actually need a full consensus of all the members to actually stop it at any point. Does that make sense, Priya?
Yes, thanks.
Okay, any other stray questions here? I'm pausing here because I want to give everybody a chance in case they have something that they were thinking about maybe raising that they were unsure they wanted to raise. this is your chance now to potentially bring something up. Okay, not hearing anything come back to this. So we can look at the exam that I gave you dealing with the situation between in the waters between Indonesia, Australia, and Papua New Guinea here, and kind of walk through kind of what you should be seeing here in case that helps. One thing I'm going to note here, I haven't yet shared the key here because as I was going through it, I realized there are things here that are going to freak you out because we talked about it that year, but we didn't really talk about it this year, and you wouldn't know about it. You might know about it because you read something stray in the book, but not be sure about it. That's cool. That's okay. Again, I'm going to be testing you on what we've talked about, not what some other classes have talked about. This will give us a chance to kind of see where some of those issues might be. I did put up the one for the other exam, which I think is closer to where we were, though again, you might see some things there that don't look like things that we saw. So make sure I got the right exam here. Okay. All right, so we've got this question here. All right, what should we be seeing? So again, just as a note here, I was asked before about, will I say what states have ratified, right? You should be seeing that in here, right? At the very beginning in the introduction to this, and I list what states have ratified. And those things are things which I try to avoid putting things into that list that are red herrings that you don't need to worry about. Right, so you can generally see that as a reasonable guide to what you should be concerned about here, right? I'm not going to put in here, these states have ratified the Outer Space Treaty if this isn't about outer space, and then have you worrying about whether or not the Outer Space Treaty is involved here, right? That's, again, I'm trying really hard to avoid red herrings. I don't want you going off in weird directions. So here, for example, it talks about Australia and Indonesia both being members of the WTO. That should signal to you there's probably a WTO issue here. It talks about Australia not having ratified the first and second additional protocols to the Geneva Conventions. That should signal to you that there's probably something with AP1 or AP2 in here, right? That's same thing here with UNCLAUSE, right? So it's giving you kind of a general sense of what might be in here. You're also seeing how here, obviously, there's going to be questions here with regards to the law of the sea, right? We're not going to have any. We shouldn't be surprised to see that. It talks about there being less than 400 nautical square miles in many places. So we know we're going to be talking about how the continental shelf might be divided. Right, so all those things are things that kind of you should see in play. The other here is you have these various agreements in place. Generally speaking, if you're seeing agreements that I've put in here, there's probably going to be at least some treaty interpretation involved. Right, you're going to it's probably going to be asking you to interpret something in these treaties. Okay, so then you've got the first question here. Again, please jump in with any questions if you have at any point. I'm talking about the possibility here of this EPA, this Environmental Protection Agreement between Australia and Papua New Guinea that leaves out Indonesia, right? And Indonesia here is upset, right? And you saw here that here you are cast as a lawyer in the Indonesian Ministry of Commerce, right? And the questions for you are, what recourse does Indonesia have? What actions could or should it take? What are the likely consequences of any action it might choose, right? So again, you're thinking about writing this from the standpoint of a lawyer in the Indonesian Ministry of Commerce giving advice to your bosses about what Indonesia should do, right? That's the way in which you're framing the legal questions here. Okay, so what are you supposed to be noticing here? So here I'll share the scary key. So this is not necessarily in the order in which you would look at this, right? Because I did this for me, not for you. Sure, I'm looking at okay. So you're going to have to figure out if there's some violation here, right? Because that's what the Indonesian commerce lawyer is trying to think about, right? Is there a violation here? So one possibility here is that there's a violation of the WTO, right? And you saw, you were kind of key to this by the fact that WTO is put into play. We talked about kind of the three-part test being in play. What could there be a violation of? Now, here's something that we didn't talk about, and I'm not going to suddenly hold you responsible for this because I'm mentioning this to you during the review session, right? So don't worry about that. The way the Mfn clause of the WTO works, right, it actually applies, interestingly, to anything you might do with regard to any state, not just anything you might do with regard to a member. So even though Papua New Guinea is not a member of the WTO, the fact that Australia gives something to Papua New Guinea that it doesn't give to Indonesia could violate MFN here. Does that make sense? Right, so that's the issue that's going on here. Then there's a question whether there's a non-tariff barrier here, which we talked about with regard to tuna, dolphin, and product and process. We talked about perhaps a little more than. I'm not sure if I would have gone here with this class. And then the Article 20 exception, and then you would be asking these questions about whether or not Australia and Papua New Guinea Australia might be able to argue that in fact it has some ability to use the Article 20 exception in order to apply this, and you go through kind of both whether it fits under one of those and the chapeau. And then, of course, there's the analysis of whether or not there's a violation. There's also the possibility here that there's a violation of the fisheries agreement that we have in the actual exam itself. Here, we're thinking about applying Vienna Convention law and treaty rules, right? So generally, they're going to have kind of these rules for interpretation. But what are we focused on? We're focused on whether or not there's been a violation of the shall work together under the agreement, right? Does that require that they actually work together? But there's also the possibility that, but it says nothing should prejudice the ability to have various different kinds of environmental protections that go beyond the agreement. And the licensing should guarantee it remains effective. But it talks about this agreement. And then there's an analysis of whether there's a violation, right? So all of this is about figuring out from Indonesia's standpoint, whether or not Australia and Papua New Guinea have actually violated the fisheries agreement. Right? Does that make sense? Right, and all that goes back to looking at the treaty. What does it require? Most of these questions, the way they're framed, there isn't an answer, right? It's not that you're supposed to be saying, yes, they did, or no, they didn't. It's all about the analysis, right? It's about the friends you made along the way, right? That's the key here, right? Which way you come out isn't the key, right? They're basically, you know what you're kind of trying to work through here in terms of whether or not there has been a violation. There's this other thing here, again, this goes to something we didn't talk about as much in class this year, right? So under the GATT, right, and under now the WTO, right, the dispute settlement understanding is exclusive, right? If you have a question about a violation of the GATT, you must go through the dispute settlement understanding. You can't go somewhere else. This raises some interesting questions here because on the one hand, that's exclusive. On the other hand, if you look at the agreement we have here, it talks about this being the exclusive means for looking at this. And to make sure I'm looking at the right part here, it says that under the Framework Cooperation Agreement, it says that all disputes between the state parties over the meaning of this agreement shall be settled through peaceful negotiation. When the negotiated settlement is not possible, the states agree to submit their disputes to the ICJ, right? So the question is then, right, is this, how are you going to read the two different exclusivity things here? On the one hand, this one only talks about meaning, right? So maybe in fact there is no actual dispute between these two different dispute settlement provisions, right? You could actually sort of do both, but then you have a question of, here again, this goes back to the strategic aspect of this. Has the Indonesian lawyer, right? What's going to be the route you want to go down? Right, what's most likely to get you what you want, right? What's going to be the best strategy for you going forward? That makes sense? Any questions about that generally? Right, so again, the way to structure this is you're thinking about this from their standpoint, right? From their standpoint, what they want to know is has there been a violation of some obligation towards them? And then kind of after making an assessment of whether there has or hasn't, what can they do about it? And that brings in some questions about both specific law that we've learned in the WTO area, though we would have talked about more that particular year as well. Like part of it's the book changed slightly between that year and this year, as I mentioned to you. The other is this question about how to interpret, which requires you to know the rules of treaty interpretation, the particular treaty provisions we have here. Pausing here to see if there are any questions about that. Are you totally freaked out? I hope not. But there's some, as I said, there's some things in here that would have been more obvious because I think we talked about this MFN issue like 5 times that year. It just kept coming up. People kept asking about it. So it's sort of like, okay, this is at the top of your minds. We're going to ask about this, right? So that clearly wasn't the case this year. Okay. Okay, so the second question then on this, I'll get the right treaty here. The second question here is dealing with this question with regard to East Timor. You shouldn't be surprised that this question is going to raise issues about statehood and the powers to actually enter into treaties and who actually has the power to enter into treaties for a particular state, right? So, and here the issue is going to be both what is the status of East Timor in 1975, right? But then also who has or hasn't been able to make treaties on its behalf, right? And again, part of the issue here is because you are a lawyer in the East Timorese foreign ministry, right? The question for you is, right, what do you want, right? So it's not just a question of what's the status of East Timor for this agreement, right? It's what position do you want to take on the status of these treaties for East Timor, right? So it requires you to kind of think in those terms a bit, right? So there are basically two parts to this, right? So one is kind of working through, and I'll try to pull up the thing again here. Sorry, it's so hard to manage all these different documents I have open for you right now. Okay. So one is trying to figure out kind of the effect of these various different ratifications, right? So the question is going to be, to what extent does Indonesia actually cover East Timor? To what extent does the Portuguese signature actually cover East Timor, and what rules, what does it give them? But there's also going to be the question about what rules will this create or not create, right? Because again, the question is, what do you want to argue if you're East Timor, right? So those are the two different kinds of things that are in play here. So on the one hand, you've got these questions with regard to Indonesia. So here's the thing about capacity. We didn't really talk about capacity this year, again, partially because of the change in the book, but there are going to be questions about whether or not you would see the Indonesian ratification as coercion, but this really isn't about coercion because this is about Indonesia itself, right? It's not, Australia is not coercing Indonesia. The question is, is Timor fit under there, but you might want to flag that. We didn't talk about fraud, but that would have been a potential thing here. But there's also going to be this question about state succession. Was East Timor a state in 1975 or not, right? No one had yet recognized it, doesn't have a right to self-determination, right? So that might be in here. There's also going to be this question about succession of governments we were just talking about, right? What should be the test here, right? How do we think about the fact that Indonesia was an effective control? At the same time, there's the fact that the Security Council did not recognize. What do we want to argue here? Again, the issue here is not just what's the black letter rule, but what would East Timor want to argue with regard to this? The same thing here with the effect of the Portuguese signature, right? On the one hand, we have the intertemporal rule, which would suggest that they were the ones who actually could act for East Timor. Does that mean that East Timor now has the ability to actually ratify it? You kind of can raise questions with regard to that. But then you have these questions about what rule do you want? And right, so we saw here that there's going to be a question about what custom or UNCLOS would allow in terms of, say, use of the continental shelf, as well as the EEZ. What rule would apply if you don't have this treaty, right? So if you have this treaty, right, then I'm trying to remember now what I said about UNCLOS, but if you have this treaty, right, then you are going to be able to get to share the mining on all in the entire area. If you don't have this treaty, then you're set trying to negotiate your continental shelf. Whether that's better or worse for you will depend on questions we don't know the answers to about how much oil is on each side, how able you are to get that oil, things like that. But that's what you're kind of thinking about. There's also going to be questions about kind of what is the rule if we're under UNCLOS or not here, right? Under UNCLOS, there's an EEZ. Under customary international law, there isn't one necessarily. So how are you going to think about that, right? Any questions about that? Does that make sense in terms of what you're seeing? Again, I'll also note as you're looking at this, as I said at the very beginning, there are way more points in here than anyone has ever gotten, ever. So no one's hitting everything. But these are things just that are there that one might be able to kind of see going on in this. Any questions about any of that? The silence is super disconcerting. Okay, and then the third question here. So we have this question now about pirates, right? And the question about what to do here, right? So here you should be seeing a variety of things playing out, right? That are going to both questions of what waters we're in, because there are things that are happening here in territorial waters as well as in kind of shared waters. That's obviously going to raise questions about things like Article 2.4 if you're in territorial waters, because territorial waters are the territory of the state. There are also going to be questions here about the status of these pirates, as well as kind of what rules will apply if you do anything against them. So to kind of bring back the kind of the key here. Again, this isn't necessarily the order you would go in. So again, it talks about here the possibility of, right? So the question here was, you're the Australian, you're a lawyer for Australia. What can you do here, right? So you have the option potentially to go to the ICJ under the original agreement, right? That's something that the original agreement allows for. Again, there's going to be this question that the agreement itself talks about disputes over meaning, not over implementation. So that would be a question here. Other options you might have, could you start policing in Indonesian waters, right? Because that's one of the things that comes up here as a possible option. And that's going to be a question about whether or not there's been a violation that you can, whether you'll be violating anything here, right? Would this violate the agreement to cooperate? Would it violate the status quo arrangements? You have to ask what the status of those status quo arrangements actually are. There's a question whether or not you could be responding to an Indonesian breach, right? Has there been a material breach of the treaty that you could respond to? And then you have a question of whether or not Indonesia has an obligation, right? And be looking at the treaty itself, you know, and asking also whether it was material, was the failure to police material, against all or especially affected, is the failure to negotiate agreements material, right? It talks about will, but then shall, and so you'd have to kind of figure out if that was actually an obligation there. And then if you start policing, right, what rules apply in the area you're policing, right? Is it IHL or human rights law? Is there an armed conflict? What's the level of the force and how does that affect attention? And then in terms of attacks in the territorial waters or rescue hostages, could you do this, right? So we think about different options, right? Option one, go to the ICJ. Option two, start policing in Indonesian waters. Option three, attack the pirates in the territorial waters or rescue the hostages. So here you have a question about jus ad bellum, right? And Article 2.4 is clearly going to be in play here. One possibility you have here is that there's consent because there's shared policings, but here there's not going to be consent because territorial waters are not shared waters under the agreement itself that you have here. You have a question whether it's against the territorial integrity or political independence to go against these pirates in these areas where they're under someone else's control. There's no Security Council authorization here, so that's why just the one here, so you can say that's not an issue. And then self-defense, right? So you have a question of an armed attack. Does this count as an armed attack under Nicaragua? Is this more than just a frontier incident? Again, I wrote this for myself, so I know what that means. If not, right, is there still the possibility for countermeasures? There's also going to be a question of whether or not the attack is attributable to the state, right? The rule is going to be effective control for that, or a possibility of unwilling or unable. And then there's going to be, I don't know what this meant here, unable or and effective control. So I don't know what I actually meant by this 4 years ago or 5 years ago. So I apologize for that. And then you have questions about, well, okay, if now you've actually engaged in this, we can't just, it's not just a question of jus ad bellum, it's also a question of jus in bello. So here it's going to be what rules apply. It's a non-international armed conflict, so it's AP2, and customary international law, necessity, proportionality, distinction. Right, you have to apply those. They're going to have the fisherman problem. Right, what do you do with these pirates who are actually fishermen who laid down their weapons? Right, and then advice on the type of attack and overall advice on what to do. Right, so that's pretty heavily weighted there. Okay. Okay. Trust me, that was actually quite tiring to walk through myself and a bit intimidating even for me to actually try to remember what I was doing there. So any questions about that? Caleb?
I guess one question would be general pointers as to when there's a broad what advice, because a legal analysis can get you a pretty nice shot at what a state is allowed to do. Will there be points though where, like, is it possible that during the exam, the best advice for the state actor you're advising is, well, maybe you could break international law and get away with it here?
Yes. I mean, you're in role, right? So you should be weighing the issue, right? So you should be, so if you're talking about something where the rules are changing and you think that even though this might go against the best legal view of the rule, but you think you might be pushing the rule in a way in which others might accept, that's the kind of thing you'd want to say, right? And the way to think about this, right, is, there's a broad swath there for kind of the quality of advice. I'm not expecting everybody to hit all the same things or everything, but the idea is to show that you're kind of weighing these kind of concerns in your head, right? You're thinking about, right, as this particular actor, what do we want to happen in this particular case, right? What's the potential blowback, of not following this or not, right? And that's kind of that kind of thing you want in there. Right, like this argument is not going to fly. This one might, but it's probably a bad idea. This one, like we actually, might be a good argument for us that, we basically get to kind of push things the way we want to go and potentially kind of are doing what we want in the particular circumstances. And that can be embedded in kind of the analysis of the rules, or it could be something separate. It doesn't have to be sort of separated out. It kind of depends on how you best want to answer the question. But again, this comes back to something I said at the very beginning of the course, I mentioned a few times throughout, right? There's always 3 levels to everything we talked about, right? One is this kind of doctrinal level of what's the rule. The second is this kind of strategic level of, okay, given the rules and the lacuna, right? What arguments do we want to make? How do we use the rules to make the arguments we want to make in order to achieve the things we're trying to achieve? And then the third is that critical level, right? What's good for the system? This question didn't have something quite like that, but there will sometimes be questions where you're in the position of, say, trying to kind of push a new treaty. And the question might be, right, what do you want here, right? What is going to be the best rule given what you're trying to achieve? Any other questions? This is really good for, by the way, sharing your sort of felt anxiety with me, because when I look at all these boxes with no faces, I can't even see how you're feeling. So I assume that you're all extraordinarily angry with me. So I'm basically this is a great way to kind of reflect the anxiety and tension back onto me. Zachary?
Yeah, I was just wondering, could you upload that key, but with the subjects that we didn't go over in class just struck through or deleted out of it? Because it didn't seem like there were all that many that we didn't talk over, just a few points here and there. Otherwise, it was mostly applicable.
Yeah, I mean, that's basically what I was going to do. It's actually up there, but hidden right now. I was going to unhide it after this. I just wanted to make sure you had that caveat, that there were things there that you wouldn't recognize. Otherwise, I was worried people might freak out. Anything else? Anything else I can help with? Okay.
Professor,
Yep.
if we think of questions, can we email you by like Friday?
Yeah, I would say so. The exam, I just want to make sure I have this right, because this year is very confusing. The exam period starts Monday, right? That's right. Okay. So I would say that basically you can ask questions until, let's say, 7 p.m. Sunday. I'll send that in an email, because that at least gives me time to, if there is something that everyone should know, I can actually send something to everyone. Any later than that, it's going to become more questionable. But I think that would be fine. Obviously before Friday is better, because weekends get complicated with kids and stuff. But I'd say by 7 on Sunday, we should be okay. Caleb?
Yeah, I'm just wondering if you had any recommendations for places where I can just get random hypotheticals or things to like help my brain go, sort of feel around and get comfortable with the material.
So I guess there are two things that come to mind. I mean, one, the book itself, right? It's this problem-oriented sort of book. The problems are set up to talk about specific things, but there are lots of other things embedded there. So, one thing you can do is you can just turn to each of those problems and just kind of try to think through, right? What do you need to know in order to start being able to work through this? Whether it's the more recent ones we've done with regard to, say, intervention in Syria, or it's things going back much earlier where you're talking about kind of Crimea and Russia, and you're trying to kind of work it through, right? So or the Argentina things. And if you remember, a lot of those issues, they've tried to actually thread through issues from one subject in the book to others in some places. So you actually should be able to kind of think through some various different things there. So with regard to kind of the Argentina stuff, you could think about, okay, well, if we don't have a bit, what would be the rule here? And that would take you back to thinking about kind of the customary rules we saw at the beginning with regard to prompt, adequate, and effective, things like that, right? Or the Calvo Doctrine, right? And how would those play out, right? What is the bit a gap against here as kind of customary international law? Has customary international law evolved since these bits, right? You had the SEDCO and TOPCO arbitrations, where we now have these bits. Later, has something changed between there? So that you can use those as a way to do this. The other, which is probably a bad idea, is to look at old Jessup compromise, but those questions are so crazy that you'll probably get lost in the examples. But really, I mean, anything you see in the news, you can kind of just be working through this, right? Because the way to think about it is just imagine yourself as one of the actors. What recourse would you have? And the first question is always going to be, who are the actors that matter here? What rights or obligations do they have? What are they bound to or not? What powers do you have or not? And kind of just work that kind of through to then figure it out. I mean, in reality, you can do this to the extent to which you have questions that are in some commercial book, you can work through it that way. I wouldn't rely on their answers, right? That's not what you're looking for. But in terms of the questions, you should be able to use the questions to kind of work through the same kinds of analysis. Anything else? Okay. I mean, if there's nothing else, I'm not going to hold all of you. And I will send around kind of a link to the recording for anybody who wants to hear all the ways in which I've made things more confusing and complicated than they were before. If you don't, feel free to ignore it. But in general, as a reminder, right, my goal here is to write an exam that you will find familiar, right? You will look at this, it will make sense to you, much more so than anyone you would be looking at from a prior year. So that's the one thing that, hopefully that will give you some solace here, right? It will look familiar. I try really hard to avoid red herrings. If something seems completely out of left field, it's probably not intended, right? I'm trying to kind of give you things that actually sort of reflect the things that we've talked about. So with nothing else, if there's nothing else, I'll say goodbye. And people around, if anybody wants to stick around for a minute because they have something specific, they're welcome to. I do hope to see all of you in happier, less anxious moments going forward. So with that,